in a case before the Tennessee Board of Water Quality, Oil, and Gas. The primary issue today is a narrow question of law, specifically, what is the deadline for a party to appeal an initial order of an administrative law judge to the Tennessee Board of Water Quality, Oil, and Gas? The appellee, Jamesway, argues that the 15-day deadline found in the Uniform Administrative Procedures Act applies, but we argue that the 30-day deadline found in the Water Quality Control Act applies. These two deadlines are in direct conflict, but the Public Act that amended the Water Quality Control Act in 2013 to adopt this 30-day deadline for appeals to the Board of Water Quality, Oil, and Gas provides the answer for how these two statutes should be construed. Specifically, the 2013 Public Act states that the provisions of the 2013 amendment to the Water Act should control if there's a conflict with the UAPA. Therefore, the 30-day deadline adopted in the 2013 Public Act controls over the 15-day deadline in the UAPA. The Chancery Court concluded that this conflict of law language in the 2013 Public Act was merely legislative history that could not be relied on in the face of codified conflict of law provisions contained elsewhere in the Water Quality Control Act and the UAPA. Jamesway also contends that the construction of law language in the 2013 Public Act should be discarded because it was not included in the codified version of the statute. However, the language of the 2013 Public Act is legislation, not legislative history. Therefore, the construction of laws provision in the 2013 Public Act has the same force and effect as any other codified statute, including the previously codified conflict of law provision. Section 19 of the 2013 Public Act clearly expresses the legislature's intent that the 30-day deadline in the Water Act prevails over the conflicting UAPA provision. That is a mandate by the legislature that cannot be swept aside or ignored simply because it was not codified. This 30-day deadline also controls because it is a more recent and specific statute under the rules of statutory construction.
I get recency here, but how is it more specific? How is this the more specific statute? And the UAPA also says that in the event of a conflict, and we have a provision that says UAPA governs. It seems like we have the same level of specificity. And recency I get. How can you explain specificity?
So specificity as it relates to the deadline itself, this 30-day deadline specifically only applies to procedures for appeal before the Board of Water Quality, Oil, and Gas, whereas the 15-day deadline in the UAPA applies broadly to all administrative appeals before any agency and board. So specific in that context. And then in the context of the construction of laws provisions, the language, the Section 19 of the 2013 Public Act is specific to the procedures set forth in that 2013 amendment.
Why is that more specific than a provision that says the UAPA will govern in the event of any general or specific conflict? And that seems pretty specific to me. You have a general or specific conflict, the UAPA's deadline is going to govern. And I still don't get why that's not at least as specific as the provision as to the 30 days.
So there is that construction of laws provision in the Water Quality Control Act, and I don't have the citation in front of me exactly, but it's the general construction of laws provision for the entire act. And our position is that this 2013 Public Act language applies more specifically to the procedures set forth in that statute, where it was amended in 2013 to deal with administrative procedures specifically before the Board of Water Quality, Oil, and Gas. Is it a great setup where they have two of these two provisions in conflict? No, but we believe it's the more specific of the two provisions.
Even if it's not more specific, you'd say it's last in time.
Correct, Your Honor. So the 30-day deadline to the Water Quality Control Act was added in 2013, so it's more recent than the 15-day deadline, which was enacted in 2000. And the conflict of law provision, of course, was enacted in 2013, and that is more recent than these other conflict of law provisions, the one in the Water Quality Control Act and the one in the UAPA, which are both enacted in the 1970s. And of course, we talked about this being the more specific statute. And that's an important principle of statutory construction because it allows these two statutes to exist in harmony. If the court held that the 15-day deadline applies here over the 30-day deadline, it would essentially completely void this 30-day deadline and effectively render this specific act of the legislature inoperative. And that certainly cannot be the proper result under the rules of statutory construction. So, in sum, looking at the language of the Public Act and the rules of statutory construction, it's clear the 30-day deadline in the Water Act applies over this 15-day deadline in the UAPA. Therefore, the underlying Chancery Court decision should be reversed on this issue, and the administrative law judge's decision denying Jamesway's motion to dismiss should be affirmed. The second issue on appeal here is Jamesway's argument that the petition for administrative appeal must be dismissed for lack of jurisdiction if it fails to state the basis for appeal as set forth in 4-5-315C of the UAPA. This argument fails for two reasons. First, TDEC did state the basis for appeal by identifying the orders it sought to appeal in its notice.
Did it identify the orders with specificity? And isn't there one order here that's identified with some level of specificity and then other orders generically that's stated?
They did use very inclusive language and referenced all orders, Your Honor. You are correct about that. But we would submit that that was sufficient under the language of the statute, which has distinctive requirements for a party versus an agency when it comes to the appeals. So Jamesway argues that the statute requires a party, in this case TDEC, to go farther and actually specify the issues that it is appealing. But this position conflates the statute's requirements for a party versus an agency. The statute only requires a party to state the basis for appeal, whereas the statute requires an agency seeking review of an initial order on its own motion to identify the issues it seeks to review. So, as a party, TDEC seeking appeal was not required to identify the specific issues it sought to appeal. It was merely required to state the basis, which it did by identifying the orders it sought to appeal. But even if TDEC's notice of appeal was deficient, the failure to specify the issues sought for appeal is not grounds for dismissal based on lack of jurisdiction. The requirement to state the basis for appeal is a procedural requirement. It's not a jurisdictional requirement. In other words, the failure to state the basis for appeal has no effect on the finality of the underlying order.
Counsel, would you disagree that it's a mandatory requirement?
I wouldn't disagree about that, but I don't think the remedy is not dismissal of the appeal entirely. Our position is the remedy is simply an order directing the party to amend the notice accordingly. And in any event, an order like that was not warranted here because TDEC had already filed its opening brief to the board before Jamesway even filed this motion to dismiss, contending that the notice of appeal was deficient. TDEC's opening brief said all the factual and legal issues it was appealing before the board. So there was no need for TDEC to amend its notice of appeal to specify the issues it sought to appeal. Jamesway also contends that TDEC's alleged failure to state the basis for appeal of the initial order was a violation of its due process rights. This argument also fails for several reasons. First, Jamesway's due process argument was not raised at the administrative level and therefore is not properly before this court. Second, there's no merit to the constitutional violation claim because Jamesway suffered no deprivation of the opportunity to be heard. As I just mentioned, TDEC had already filed its opening brief by the time Jamesway filed its motion to dismiss. So the opening brief set out all those legal and factual issues, giving Jamesway sufficient notice of the issues for appeal. Jamesway subsequently filed its opening brief and thus had full opportunity to be heard and respond to the issues TDEC raised. Accordingly, Jamesway's due process violation argument lacks merit. The last issue we are here on today is Jamesway's request for attorney's fees. Jamesway sought to recover attorney's fees in the Chancery Court, but Chancellor Martin properly denied or declined to award them. Jamesway has renewed its request for attorney's fees here. However, the UAPA only allows attorney's fees to be recovered when there is a final decision in a contested case. For that reason, attorney's fees are inappropriate at this juncture because the order at issue here is an interlocutory order, not a final order. The UAPA also only allows attorney's fees to be recovered where the respondent shows that the claims against it were not warranted by existing law and not supported by the evidence. Jamesway cannot meet that burden here because TDEC successfully established that one of the violations it asserted against Jamesway in the underlying administrative case. Accordingly, attorney's fees are not appropriate at this juncture and should not be awarded at all. For all the reasons I've stated, we'd ask the judgment of the Chancery Court to be reversed, the administrative decision denying Jamesway's motion to dismiss be affirmed, and the request for attorney's fees be denied. Thank you.
Thank you, Ms. Wyatt. We'll hear from you on rebuttal. Good afternoon.
tell you, it gets darker every time I come in here. It's like, I don't know if I'll be able to see up there. May it please the court, I'm Sharon Jacobs here with the Nashville Bar, here on behalf of Jamesway, and I'd like to introduce my co-counsel, Patrick Clark. He's relatively new to the bar, first time here, and I think he's pretty excited to be here before y'all.
You're welcome.
So thank you. I would like to address, I think, first and foremost, that this is a question of law. I think, as Your Honor has pointed out, this is a construction of a statute with the application of the law to the facts of the case. It's de novo review. There's no presumption of correctness, although we do believe Chancellor Martin got it right. She didn't agree with everything with us, but we think she got it right. What happened here is basically a violation of statutory provisions and an unlawful procedure. This case is about the state violating very specific statutory provisions in exceedance of its delegated authority by appealing a final order, which is all rooted in TDEC's untimely appeal. The commissioner's order was issued December 28, 2018. And these dates are important because the statute upon which they rely, 110A in the Clean Water Act, lays out very specifically how many days you have until the ALJ has to have a scheduling conference. And in this case, we appealed October 24th, 2018. No scheduling conference occurred until a year later, on September 13th, 2018. It's supposed to be 30 days. A hearing was held ultimately September 27th, 2021 through October 30th, 2021. We know that was kind of the time of the pandemic, so we're not going to argue with anybody about whether anything was done timely during that time period, but this was well before the pandemic, our appeal. And the record of the hearing was finalized May 10th, 2022. The ALJ had 60 days to issue his initial order. He passed it by 2 months. He issued his initial order almost a year after the hearing, but clearly 2 months late after when it was due, according to 110A under the Clean Water Act, the very statute that they say is the one that controls for the 30-day appeal. And we would submit, and we submitted to Chancellor Martin, that while we believe that the 30-day never applies under the Water Act, it doesn't really matter in this case because it can't apply here because none of these other deadlines in 110A were complied with at the ALJ level.
So, Counsel, is this essentially a package deal? If you're proceeding under the provision in which the 30-day language appears, you have to sort of check all the boxes. You have to check the first box, second box, timing has to have all played in, and then the 30 days becomes relevant.
That's exactly right. And I'll read you the statute. That's exactly what it says. ALJ shall convene a scheduling conference within 30 days of the petition of appeal filed. Didn't happen. Scheduling order issued by ALJ shall establish a schedule for the hearing and result in a schedule that results in an initial order being issued within 60 days entry of the record being final. It was 4 months. It wasn't 60 days. And the initial order and all prior orders shall become final within 30 days of the initial order unless that order is appealed to the board. So they're correct. If 1, 2, and 3, or it doesn't matter, only one of them, has to be not met probably, but I'm saying 1 and 3 were not met at all. There was no attempt by the agency, and in this case, the agency is not TDEC under the appeal process. The agency, as admitted by the Attorney General in Chancery Court, would have been the board. So they are a party to this lawsuit. TDEC is right now. The agency under the UAPA is a board because they're the ones who can issue findings of fact and conclusions of law and have the authority to promulgate regulations. Only under the UAPA. I know normally we would refer to it, but if you look at the Fentress County decision that is as old as I've been practicing law, and I argued for the state when I did it, the board is the agency under the UAPA for purposes of that appeal. That was a shock to me to hear for the first time today that TDEC or the commissioner now says, oh no, we don't have to comply with the party provisions because we're the agency appealing. Well, no, the board is the agency appealing if they lose, you know, if they're before here. But the board's not here. It's TDEC, the commissioner, and the TDEC itself. And I know that agency, there's a whole bunch of law on it, and I wasn't prepared to talk about it because it's always been agreed for the past 25 years, 30 years. So to get back on track, but you're right, Your Honor, that's exactly right. We say that 110A under the Water Act, it may apply. It doesn't apply here. Now, it probably shouldn't, but you know, we're not asking for an advisory opinion. We're asking for an opinion on the facts as they're submitted here, and the facts are uncontroverted. There was no scheduling conference within 30 days of our petition for appeal, and the initial order was not issued within 60 days of the record being final, period. And you want to talk about specific over general, well, that's specific.
Was there a request for a scheduling conference?
Pardon me?
Was there a request made for a scheduling conference?
I
require a request.
It's required by statute, and I have had a lot of these, and the ALJs are usually right on top of it. With this one, it didn't occur, and honestly, it's been a while, and I can't remember, but there was other parties involved, and whether or not they timely filed some of them didn't timely file petitions for appeal, and so then there was a default judgment and all sorts of stuff. But the statute's mandatory. You're gonna have to have that scheduling conference. They should have had it with us. And even if they didn't, even if they had, the ALJ still didn't issue an order that required his, a scheduling order that required his initial order being issued within 60 days of the record being final. That didn't happen. And he didn't do it. So not only did he not issue an order that said he would issue an initial order once this record became final, he also didn't comply with it. And it's all contingent upon the ALJ issuing this initial order. And what I found incredible was that the state's position, they specifically stated that they thought it was, I want to quote the language exactly from what they said as far as it being prejudicial, impractical, and prejudicial to make an appeal requirement contingent upon the actions of the ALJ. Well, I mean, the state statute's pretty clear. And all appeal rights are based on when you get your orders issued. I mean, I'm not sure how that's impractical and prejudicial. And the backdrop of all of this is that in 2022, in April of 2022, the legislature enacted 45326 that says the court shall resolve any ambiguities against increasing agency authority and oversight. You're not to defer to the agency's interpretation, and you shall interpret, like, as you already know, the statutes and the rules de novo. But if there's any kind of conflict, it goes on the side of the regulated community and the citizens and the taxpayers of the state, not on more regulation. Our position is that the 30-day deadline in the Water Act found in 110A, could be decided or not if it's relevant in all matters, but as the facts are applied here, it can't be, because none of the prerequisite mandatory timelines were complied with. And therefore, the 15-day Uniform Administrative Procedures Act deadline was complied with, which is 4-315B. In contrast, the state also, in their brief, cite to the Air Act, the Petroleum Act, Hazardous Waste, Solid Waste Acts, and say, oh, you can't do this because you're going to gut all these environmental statutes. Well, it's interesting. Out of curiosity, Chancellor Martin did this, and so it prompted me to do this, is none of those other statutes have the language the Water Act has under Public Policy 102, which is all procedures in this part of the Water Act are to be in conformity with the UAPA. None of those other acts have a construction of laws section, which is 120 under the Water Act, 69.3 120, which says all procedures in this part are intended to be in conformity with the UAPA. If any provision, as you pointed out, Your Honor, if any provision of this part conflicts with the UAPA, then the latter shall govern. So not only does this have no bearing on any of the other environmental statutes, none of those others even had that language. So it kind of maybe makes sense why there's that note, and it wasn't codified in it as far as in 110 saying, hey, this is going to
Is it
apply.
really legislative history, though? And Chancellor Martin seems to have described this as legislative history. And this is a provision passed by the General Assembly and the 2013 statutory measure. And isn't that a questionable characterization of a public act?
Well, I don't think so, because TDEC, before the ALJ and before the Chancellor, argued it was all legislative intent. They changed their position only here. And we submitted that they should be, judicial estoppel prohibits that. Well, actually, I think they tried to change it during oral argument, but it wasn't briefed in front of the Chancellor, and she wasn't buying it because they talked about collateral estoppel versus judicial estoppel. But the argument before the ALJ on our initial motion that you're untimely, your motion to dismiss, and that this order was final, the TDEC response in that initial matter was, it's legislative history. You have to refer to the legislative history, and here it is. And so it trumps all this other stuff. But even if that was true, you have to comply with the rest of the statute. You can't pick out one sentence and say, oh, this 30-day applies here, but none of this other stuff applies to us because it's prejudicial. That is going way beyond any delegated authority that's been delegated to TDEC or the agency, in this case, when you're talking about the general term, to interpret that.
45315C question, in terms of the petition for appeal shall state its basis. Later in the same section here, there's a subsection, shall identify the issues that it intends to review. That seems to draw some kind of distinction between basis and issues that it intends for review. Are you asserting that they mean the same thing, or is basis more limited than issues intended for review? And if it's more limited, what do you have to show for a basis, to state a basis?
I don't think they're the same, and that was discussed before Chancellor Martin, and she just didn't rule on any of that because she got to the, plain and ordinary language, and it was so clear, and two things in the Water Act and, in the UAPA. We don't think they're the same, and here's why. When I have to appeal a commissioner's order, I am charged with identifying the specific provisions by which I appeal. Not the basis by which I appeal it, but the specific provisions. I liken this appeal as the same thing. Those are required when a commissioner's order is issued under the UAPA, that you're supposed to identify what you're appealing with some specificity. Not, I appeal the entire commissioner's order, which would include Jamesway as a Canadian corporation. Well, I can't appeal that because they are. So with specificity is like responding to a complaint, 1, 2, 3, but not with that much, In general, it would be, the reason we think that's important here too is to state what they were appealing is because they had a backroom settlement with one of the other parties in this after the hearing and after the initial order was issued. Sometime between their appeal or whatever, they're the party that held the permit. They were the party that was on this property first. They were filling this property for a year and a half, 2 years before our client ever got there. And they removed them as a party and filed their appeal saying we're appealing everything, and now that party's no longer a part of it. And so we didn't have any notice of that. And for that reason, we thought that they should have identified, okay, we're appealing the allegations as they pertain to Jamesway. That would have been stating what you appeal, but instead they just said they appealed everything, and then they go and have these backroom settlements. And now we're stuck. So, it's no different than me having to appeal one of their commissioner's order. I have to state some specificity. Why is it that I'm held to a different standard than the state? It's mandatory statutory language. Again, I go back to everything has to be construed against less regulation, not more. So I didn't get into everything, of course I never do, that I want to talk about, but I think the general and overview is that Chancellor Martin did not give us attorney's fees because I told her we weren't asking them from her, that if this was a final order after 15 days, then the ALJ is the proper entity to decide that. What we do ask before your court is that the appeal, if there is an appeal of a final order, and that order, if you agree that that was a final order within 15 days, TDEC under the Water Act is prohibited from appealing a final order under the Water Act. Again, not under air, not under any of these others, just water. They're prohibited. They violated statutory law by appealing a final order. And for that reason, we ask for attorney's fees before you, only on the appeal section, not on the administrative hearing section. We think the Chancellor got it right, and I appreciate your time. Thank you.
All right. Thank you, Ms. Jacobs. Ms. Wyatt, your rebuttal.
The first thing I'd like to address is Jamesway's argument that there is this conditional language that they are reading into the Water Quality Control Act deadlines found in 110A. It's simply not there. There is no requirement that the ALJ meet the other deadlines that are set forth in the Act for the 30-day deadline to apply to a party seeking to appeal the initial order. It's simply not there. And it would be prejudicial to condition whether the party has a 15-day deadline or a 30-day deadline on whether or not the ALJ independently is meeting these other deadlines within the statute. So it's the state's position.
Is it a way of harmonizing these provisions? And if you have a measure that lays out, you're bringing a certain type of challenge, you set it within this many days, you have a determination within this many days, then you get 30 days to decide whether you appeal. But if not, then it's going to be the 15-day provision. Is that a way of harmonizing these seemingly conflicting measures, or do we still have a conflict lurking out there if we do read it as a package deal?
So I think that let me think about how to answer that. So the deadline set forth in the Water Act, I don't think it's a way of harmonizing the two. I think the intention of those procedural deadlines in the Water Act, if you go back and look at the legislative history behind this and those other amendments to the other environmental programs where they set forth different procedures for administrative hearings for the specific boards in those programs, it was to separate that from the UAPA, provide some more uniformity for those specific environmental programs and boards, and frankly shorten the time that it takes to get through an administrative procedure. But it's not, I don't think there's a way to harmonize the UAPA and the Water Act here through a conditional reading of those deadlines on the deadline for a party to appeal. And frankly, there's nothing in the statute that says if these deadlines aren't met, then the default is to the UAPA deadlines. It just doesn't say that. And the clear language of the Public Act, again, in that 2013 amendment is these procedures, these deadlines are to trump the UAPA deadlines. And Jamesway argues that TDEC has had an inconsistent position on that throughout this appeal process, or since the administrative hearings, but that is simply inaccurate. throughout the entire litigation, it's always been TDEC's position that that language in the Public Act it mandates how these statutes should be construed. Now, did it become apparent that we needed to up our argument about the fact that this is not legislative history, this is actually legislation after the Chancery Court order? Yes. So we have emphasized that more now because it's obvious that might be taken for granted for some attorneys and for some judges, and frankly, I didn't know how the Public Act works in relation to codification until I actually had this case. So I understand why some attorneys might think that might be legislative history, but it's not. It is legislation. Jamesway's argument that the court should construe this deadline against increasing agency authority. Also, that's not applicable here. This deadline applies to any party appealing an initial order, not just TDEC. So if the court finds that the 30-day deadline applies, it's not increasing agency authority. It's simply finding that a 30-day deadline applies to any party seeking to appeal an initial order. And finally, the issue of attorney's fees. If this court does agree with the Chancery Court and upholds that decision and finds that this was in effect a final order, the court attorney's fees are not appropriately awarded here. It still has to go back to the ALJ to make that determination under the UAPA. So for those reasons, again, we ask that the court reverse the Chancery Court's decision and uphold the administrative law judge's decision denying the motion to dismiss and decline to award attorney's fees. Thank you.
What about the attorney fees on appeal? Can this court order those attorney fees and send it back?
No,
or what?
I'm sorry. No, Your Honor. I believe that it has to all go back to the administrative law judge to make that determination. Thank you.
All right, thank you, Ms. Wyatt and Ms. Jacobs, for your arguments. We'll take this matter under advisement. That concludes the afternoon docket.